Monday, we don't have enough. I think that list is full on Monday.
Admission only on
13 February.
okay, Lordship.
May I please, your lordship?
Mm.
This is an old pending matter, lordship. I'm fixed for hearing, lordship.
Mm.
I'm for respondent. They are enjoying the interim order, lordship. 19 case. It may come for hearing, lordship.
It will come for hearing, sub hearing okay.
February 9.
List is full. All the dates are full. We won't be able to take up the hearings we have fixed earlier.
Lordship, deeply.
May I please, Lordship? Okay, I'm paying for listing of a case for orders, coordination matters, Lordship.
On
Monday.
Monday, fine.
Orders matters. Obvious.
May it please, your Lordship. Lordship, I beg to mention for listing one in-test case, my lord. It is very odd, 17 case, my lord, for hearing. May I pray any date in the month of February, my lord?
February fine, not on February.
17th, my lord, till
5th month.
May I please, your lordship? I'm beg to mention an embassy appeal for listing. So kindly it may be listed on the month of February for orders.
For orders.
For orders.
Or data orders.
11. Highly obliged. your lordship.
May I please, Lordship? I beg to mention a batch of MSc appeals, my lord, of 5 appeals. To come in the admissions column, my lord. Can it be on the any date on the next week, my lord, or
Admission column.
20? Yes, my lord. In it.
May I please, your Lordship, with the consent of other side, I beg to mention item number 13. Lordship, matter may be take on 5th March, Lordship.
Then your name?
K. Bhattacharya,
Learned Counsel Mr. K. Bhattacharya.
on behalf of K. Bhattacharya, A.U. Ahmed. Lordship.
Learned Counsel Mr. A.U. Ahmed on behalf of Learned Counsel Mr. K.
My lord, I am
Bhattacharya.
for the respondent, my lord.
With the
My lord,
consent of the other side has prayed for adjournment. Your name?
HP Gwala, my lord, date may be, my lord.
Learned Counsel Mr. H.P. Gwale is present. List the matter on
5th March. 5th March. If it's positive. Lordship.
Obliged.
May please, the Lordship. Lordship, I'm praying for listing MSc appeal matter. Lordship, though this matter is was fixed today, but it is not come into list. And in Lordship, it is unfortunate. Last 5th occasions, hearing was not done, and the appeal has been admitted without paying the 50%.
MSc appeal. We are
Yes.
paying the 50%.
Yeah. Lordship, I'm praying, Lordship, this matter was fixed today, for today, but it's not come in the list. So, Lordship, is next week if possible, Lordship.
Not on next week. Data deduction hearing okay. Not on next week.
17th February. Highly obliged.
Lordship, I pay to mention for listing of an MSc appeal in orders column, Lordship. Actually, we have filed this case in the August 2025. Till now, it has not been listed, and now in the meanwhile, Bakija proceeding has also been initiated. So only
Yes.
50% deposit in Monday, Lordship, if possible. Orders.
Orders column fine Monday. 11th on 11th. It will be Tuesday or Wednesday.
Obliged.
May I please, your lordship? I beg to mention listing a CRP matter, lordship, for admission. Lordship, a maintenance case fixed 23rd February before lower court, lordship.
Sakso? 20th.
20.
Maybe the Lordship, I beg to mention for urgent listing of MSc appeal. Lordship, the matter was last listed on November
For
of
hearing?
last year. For orders, admission, Lordship.
Admission.
Maybe on 11th of this month,
Sakso?
18th. Yes.
Please, your lordship, I beg to mention one RSA. The matter was last pending for no lordship. It's a RSA which is pending since long for hearing. So kindly fix a date for orders so that we can fix a date for hearing, lordship. 13th. Obliged.
May please, your lordship. Lordship, one method is for the orders method, lordship, on 2025 year. This was description, lordship. Method will be fixed for orders, lordship. Please, 16. Lordship, and lordship, another method is for hearing method, lordship, and that method was last posted on 4/12/2025. On the date of Lordship, the other side was not acquired according, matter was fixed for after 3 weeks, but till now, Lordship, matter is not listed.
Hearing?
Hearing matter, Lordship.
Okay, date the video hearing again.
17 March 17, March of this Lordship.
May I please your Lordship? Lordship, I beg to mention for listing of 2 matters for orders, Lordship. On next week, Lordship. 20.
May I
Right,
please,
Lordship.
may I please, Lordship, I want to mention regarding listing of 2 MAC appeal of 2017, Lordship. Next week on Thursday in the
For
admission.
hearing?
For
Admission?
admission, Lordship. Of Thursday, Lordship, next week. Bless you.
May I please, Lordship, I beg to mention one CRP, Lordship, for motion, Lordship. Lordship, on 22nd January, matter was filed, Lordship. Lordship, on Monday.
Motion of section?
Yes.
Mediation Lordship. That's not a fit case for mediation Lordship. When there is a violation of policy condition.
Just now, my friend has given me a copy of an application.
We are going to file today, Lordship. I just have the copy.
File for a night.
Just for
Let it come up on February 19. 24th of February for hearing. In the meantime, we will file objection against this petition. So this cannot be settled before the local Adalat.
Learned Counsel Mr. S.K. Goswami is present for the.
Our Sharma Lordship.
Arsoma is present for the insurance company and learned counsel. Item number 1. Your name, learned counsel
H.
Mr.
Das.
H. Das is present
One,
for
two.
the claimants. Claimant?
Yes, claiming 1 and 2, my lord.
Post of- It is submitted that this case has no element of settlement. Is this matter on 24th? 24 fine hearing or kind.
24 is Tuesday, my lord. Your lordship can, my lord. It's a small matter.
There are too many matters.
My lord,
Better
can it
the
be
date,
on 26 in that case?
February, we cannot fix on February. For hearing, we cannot fix any matter for February. We can place it on orders column because you are about to file an objection.
My lord, even if I don't file objection, I can argue before your lordship, and for your lordship, it's a
Then
very
the month
small
of
matter.
March, huh?
For your lordship, it's a very small matter. 5th of March, my lord.
Yes.
बहुत piece हुआ है जो।
17 March, yes. Because I think other matters will be left over. I think other matters will be left over there. We require one more civil bench one.
My lord, 17 March.
We already have, we'll require one more.
17 March.
Yes.
Deep level.
May I please, lordships.
Lordship matter may be passable for the time being as my senior likes another post.
This is whether this matter is nothing to be argued or any submission to
My
be
lord.
made.
Lordship,
Only you have to say whether there is any element of settlement.
Lordship,
Yes,
I
so-
take my senior notes. Lordship.
There is no sense, as already, my lord, and several locations we have tried, my lord.
In the mediation.
Yes,
center.
yes, but not mediation, but just directly to the companies, my lord.
Okay.
And my lord, in this case, my lord, we are the victim, my lord, the deceased wife, my lord, and the minor sons, my lord. And in this case, particularly, my lord, unfortunately, my lord, earlier, my lord, there was other counsel, my lord, but there is no any order like 50% deposit of the awarded amount, my lord. That's why, my lord, petitioner is suffering since, my lord, the day of accident, my lord. Without, my lord, the sole earning person, my lord, they are suffering a lot, my lord. And my lord, today, as per last order, my lord, of this honorable court, my lord, today is fixed for final hearing. As I have, my lord, placed, I have filed a, my lord, IA for seeking direction to the insurance company to deposit 50% of the awarded amount, my lord. But on that day, my lord, as the matter will be heard on, supposed to be heard on today, my lord, that's why, my lord, that IA was not taken, my lord, on last
Okay, then
occasion.
fix it for final hearing.
Final
Or
hearing, my lord,
fix it for orders.
to
For IA.
IA, my lord, IA was not taken, my lord.
So what to do? You suggest?
My lord, that's a matter is, that's why, my lord, matter is fixed for final hearing today, my lord.
So we
But-
cannot hear today.
But my lord.
We cannot hear because you see, we have to.
Yes, my lord,
go
you
in
can
the
call this
the
test.
Other side also, because it
Yes,
has
sir.
come.
Then, my lord, a short date may kindly be given for final hearing, my lord.
Short,
Short
no,
date,
no.
short date. Otherwise, my lord, since
For final hearing, we cannot give you a short date. It's very difficult to accommodate for
My lord.
final hearing.
as per recommendation, convenience, my lord. We came on command.
Learned Counsel, Mr.
J. Kalita.
J. Kolita is present on behalf of, on behalf Nalagi. For the, is present, Nalagi, for the insurance company and Learned Counsel, Mr. M. Ahmed.
S. Ahmed.
S. Ahmed is present for the claimants. Full stop. It is submitted by the Learned Counsel, Mr. S. Ahmed, that there is no element of settlement. Full stop. It is also submitted that earlier by the order dated 15/12/2025, this case was fixed for final hearing. Full stop. The appeal was admitted without any order without any order directing the insurance company to deposit 50% of the compensation. Full stop. The injured victim is suffering immensely owing to the pendency of this case. List this matter for final hearing on without fail.
If February, my lord, if possible, my lord. Other, huh? Obliged, my lord. Obliged, my lord.
Lord, this matter, in fact, cannot be settled in the mediation because driving license is fake. So therefore, my lord, the company will not be in a position to settle it.
Learned Counsel, Learned Senior Advocate Mr. S. Doctor has submitted that there is no element of settlement. Learned Counsel Mr. S. Islam is present for respondent number 1 to 4. This matter, this case is fixed for hearing.
For hearing, service is complete.
List this matter for hearing on data deduct 19 March.
19, all. Obliged.
Your claimant or insurance company?
I'm for the claimant, Lordship, respondent number 1.
That insurance, where is the insurance company? RD Muzumdar. Can we wait for some time?
Lordship, this matter needs to be heard, Lordship. Kindly fix a.
No
for hearing.
settlement. Learned Counsel Miss
M. Nirula, Lordship.
M. Nirula, no?
Yes.
Is present for the claimants.
Appellant, Lordship, yes.
Is present for the appellants and has submitted that there is no element of settlement. List this matter. Readings are complete.
Yes, Lordship. This matter was earlier fixed for
List this,
hearing.
do you want a date?
Yes, Lordship.
List this matter for hearing on data review. 19 March.
Obliged.
Result Lordship. I filed one IL Lordship, that is 1700/2025 Lordship. In this IL Lordship, we seek the withdrawal.
No. You want to withdraw?
No, Lordship, for withdrawal the money, and for that
No,
purpose already.
not today.
Your Lordship, this matter cannot be settled in mediation. It's not a fit case.
Already.
We'll fix another date.
Lordship, already whole money has been deposited.
No,
by
today this matter is not
Yes.
fixed for, we'll fix another date.
Yes, Lordship.
Learned Counsel Mr. D.K. Kolita
DK Kolita, Lordship.
is present for the claimant and Learned Counsel Miss
A. Biani.
A.
Biani.
Bhiani
Biani, yes, ma'am.
is present for the insurance company and has submitted that there is no element of settlement. List this matter for hearing. List this hearing no. List in orders column.
Orders.
List this matter in the orders column on 23rd March,
23rd
February.
muscle.
Much obliged, Your Lordship. Your Lordship, can it be towards the end of February? Any other date
23rd is the end of February. We have only 5 days to go.
after any other date other than 23rd, Your Lordship?
Delegate dates.
27. Much obliged, Your Lordship.
Muscle.
Please, Your Lordship. Lordship, the engaged counsel is on legs in another court. Kindly pass over for time being, for some time. Your Lordship, my preparing for the respondent. Time being.
Insurance company.
No, Your Honor. It's a
For the claimant.
matrimonial dispute. Your Honor, it's a matrimonial dispute. It's a matrimonial dispute.
Okay. Matrimonial dispute. Is there any element of settlement?
No, Lordship. They have filed for condemnation of delay, Your Honor. After the judgment, they have applied for this.
Learned counsel, your name?
My name is MN Konyak, Lordship.
MN?
Konyak.
Konyak
The English
is-
counsel is coming, Lordship.
No,
Mr. G.
not
Chaudhary.
required. Learned counsel, Ms. ML Konyak is present on behalf of learned counsel, Mr.
G. Chaudhary.
G. Chaudhary. Full stop. Learned counsel, Ms. A.G. Chaudhary
Yes, Your Lordship.
is present for the respondent and has submitted that there is no element of settlement. Full stop. Thereby list this matter. It was at which stage? Orders column. Thereby list this matter in the orders column on. When do you want? Huh?
Next week, Your Lordship. Next
After 1 week.
after 1 week.
Date নালাগে after 1 week দি দিলে তেওঁলোকে registry date টো ঠিক কৰি ল'ব নহলে ইয়াতে you can mention also if you want another date.
They filed a petition for condemnation of delay, Your Honor. There is no scope for this one. The matter may be rejected because after.
No, we will hear when this matter will be fixed in the orders column. Now it's fixed only for referring to the mediation center. So we'll hear you when the matter comes up at orders column.
Yes, Your Lordship.
Obliged.
Lord, in support of my plea that there was a manipulation, my Lord, fabricating of the amount, my Lord. I would take your Lordship to one document, my Lord. Your Lordship will find at page number 66.
Page number 66.
66, my Lord. This is the manual copy of the application form for marriage, my Lord. Page 66. Serial number 6, my Lord.
Application for
Marriage application, my Lord.
marriage registration.
It is not for registration. This is the manual application, my Lord. It is filled in hand, my Lord. And on the basis of the information made herein, my Lord, entry made herein, final certificate is issued, my Lord. So this is the manual copy application form. It is filled up.
What certificate? Cabin number?
No, my Lord. This is the, because there are two procedures that on the date of marriage, my Lord, one application form is filled up, my Lord. And based on the entries made herein, final certificate, that is cabin number, is issued, my Lord. So this is prior to the issuance of cabin number. So here in serial number 6, my Lord, I draw your Lordship's attention.
Oh, that manipulation of the dower, that
My Lord,
case.
my Lord, that case.
We have already heard, no?
No, my Lord, today that your Lordship was pleased to held in earlier that you, if you want to make some submission, then come prepared. And even if there are some rulings along with the rulings also. So therefore, I am taking few minutes, my Lord, to justify my contention that there was a manipulation. So
Okay,
serial
but
number 6, my Lord.
that we agree with you. There was
My
a manipulation.
My
Okay.
Lord. So therefore,
Now what?
now the judgment says, my Lord, the judgment said that the cabin nama that was produced before the learned court below, trial court, that has been duly proved. And what is the pretext that? Because the issuing authority, that is the Qazi, he was examined. But my question is that, my Lord, if I myself is the privy to the commission of the offense, my Lord,
I understand. Yes.
my Lord. So that part is my.
According to you, Kazi has
Yes,
manipulated.
my Lord.
along
Yes, my Lord.
with
To that effect, my Lord, I cross-examined him. And he also admitted that, yes, there was a overrating or there is a change in the figure, my Lord, or the amount. So if that was
in
there,
connivance with the
My Lord.
bride's family,
my Lord,
that Kazi has
Yes, my Lord.
manipulated that amount
Yes,
from
my Lord.
5 lakhs to
Yes, my Lord.
51,000, from
My Lord.
51,000 to 5 lakhs.
My Lord, because page number 40, that is the evidence of Qazi, my Lord, PW5,
Manipulation of the dower, no?
my Lord,
Moharana.
my Lord, Moharana. Moharana.
Page 40.
Yes, my Lord, page 40 is the evidence, my Lord, of PW5, that is Qazi, my Lord. May I read, my Lord?
Yes.
I appeared before this court after receiving summons. I have been working as the Qazi at Pub Matia I have solemnized the marriage between the plaintiff and the defendant on 19/9/2010 by executing a kabinnama, putting my signature in the said document and also obtain signature of both the bride and groom, including witnesses. Exhibit 1 is the kabinnama and Exhibit 1(3) is my signature. As per manual agreement, both the parties mahar of rupees 5,70,860 only, out of which the groom paid rupees 6,350 only. To the bride, and remaining amount was to be later on. Then said kabinnama was countersigned by the district Qazi Yusuf Ali. Exhibit so and so is the signature of the district Qazi. Then cross. I have not brought authorization letter as a Qazi. I have not submitted application form in respect of marriage. I have not submitted application form. That was initially filled, my lord. That he has not submitted. Both the parties submitted application form of marriage with their signatures. Today I saw a Xerox copy of the same with eraser mark in the amount noted down in the word, but not in the numeric. So he has also admitted that today I saw a Xerox copy of the same with the eraser mark in the amount noted down in the word, but not in the numeric. So, my lord, compared to this, my lord, the Xerox copy which shows some many, my lord, the alteration or change in the amount.
Where?
My lord.
Where is the eraser mark?
My lord, paragraph 5, my lord, cross examination, page number 40.
Eraser mark.
Oh, here is the mark. I have short your lord, page number. Page number 66, my lord.
Which one?
Serial 6, my lord,
column?
Mut Maharana. That.
Mut Maharana,
Yes, my lord. 5,17,860. So this amount, my lord, it is written in digit, and then if your lordship is pleased to peruse the amount written in letters, my lord, words. Here is my lord, the discrepancy, my lord. Because under no stress of imagination, my lord, this amount can match the amount that was earlier. Because if your lordship, if we presume, because the document shows that it was actually written as 51,000, my lord. But there are some change or fabrication. Subsequently, my lord, this 5,17,000, even the my lord, the spelling of the words, that also does not tally, my lord, or does not appear to be correct. And it expressly shows that it was later on, my lord, changed and fabricated, my lord. So my plea was that the Qazi himself was the plea.
No.
So based on his,
No.
my lord.
This is the form. This is not a kabinnama.
This is the form we filled up, my lord.
Page 68 is the Kabinnama, my lord.
Kabinnama is
68.
My lord, I'm coming to that, my lord. Because this is the form which is filled up on the date of marriage, my lord. And kabinnama is issued later on, my lord, based on the entries made in the application form, my lord. This is the procedure. Kabinnama, because he has made it later on, my lord, as per their wishes, my lord. There cannot be any variation or other thing in the kabinnama, my lord, because it was prepared later on. But initially the application form. But my lord, for a moment, if I made
What was the findings of the court?
The finding of the court was that since the petition respondent here, the wife, brought the Qazi before the court, and the Qazi has admitted that yes, he has issued the certificate, then the burden of proof was discharged, my lord. That was the view of the court, but that cannot be, because, my lord, if I myself is a privy to a, my lord, offense, commission of the offense, then my evidence.
Case registered against the Qazi?
One case was filed, my lord. That was pending, but for some reasons or other, my lord, that I could not produce the original copy of the application, because, my lord, the original copy remains with the bridegroom, my lord, with the bride, my lord. What the why? Original, because marriage certificate, application as well as the kabinnama, this remains with the wife. So I could not produce the original copy of the, my lord, this application form. Therefore, my case was not considered, my lord. And subsequently, it was of course dismissed because I could not produce the certificate, and accordingly the court did not believe me, and therefore the criminal case was. But
No.
That is my case. With all respect, my lord. My lord. This is my case.
Why don't you both settle the dispute that you make some settlement in the this maintenance, and then you give the Muharana?
Because it is up to your lordship, because this is my case, I with all respect, I have submitted, my lord. So I leave it to
pass any order.
my lord.
Why don't you make a settlement? Why don't you talk to the bride, and then if it is very difficult for you to pay 5 lakhs, Bride will also consider, I am sure she will consider.
But the fact is that, my lord, she is not considering it. This is the,
Yes.
otherwise, my lord, I am a salaried person, my salary is fixed salary, 14,000. Out of that, my lord, 7,000 I am paying, my lord, in the maintenance case. And even
Can-
she has
can
filed
you
another
accept
DB case, my
the
lord.
right-
He's also not paying the maintenance amount regularly, my lord. About my lord, 3 lakhs odd, my lord, pending in the maintenance award, my lord. He is not paying the maintenance regularly. He's though he's a my lord,
See, this
tutor,
is
my lord.
What benefit I am asking?
No, my lord, I am
It's not
subject to
for
the
his
correction, my lord.
benefit I am asking.
Subject to the correction with your lordship's approval. My lord, I am paying the 7,000 per month, I am paying regularly, my lord.
No, you.
But to some extent, there are some areas, that is some, I know, sir.
You have
I-
no ground to dispute.
My
You see, this case,
My lord,
it's not good.
my lord,
This case is
my
not
lord,
good.
I understand.
So why don't you pay, why don't you make some settlement with the Moharana amount? If you're not willing, then we'll proceed with
Then in
it.
that case, one opportunity may be given, my lord, I will make another attempt, my lord.
But I have given you several opportunities. and
But,
this
my
is
lord,
the
that's-
second day.
This may be decided, my lord. Lordship may decide this petition, my lord, civil
This is the
civil
second day,
division.
I think.
My lord, my
My lord, this is the 3rd day, in
Mm.
fact, my lord.
Mm.
So, my lord, Lordship will decide this petition. Let him file an application before the competent court, my lord, for reducing the, my lord, amount of maintenance. In that case, my lord, he will, perhaps the respondent wife also, my lord, she can consider, my lord, if he is not in a
Yes, my-
position.
that
But,
can
my
be
lord,
done.
as per my instruction, my lord, he is running a tutorial home. About 80 students are there in his tutorial home. He's a BCA teacher, my lord. He has got enough income, my lord, as per my instruction. But he is intentionally avoiding payment of the maintenance also, my lord. Apart from the Maharana amount, my lord, he is not also paying the maintenance award, my lord, regularly.
I will not
Around-
admit it.
No, my lord, it is up to your lordship, my lord. But the fact is that, my lord, this is the problem. I am a salaried person. I am a tutor, my lord, now, with a fixed amount, my lord. And the government circular says that a teacher or a professor or any academician who is working in a school or college, they cannot go for any private tuition. And the other side is saying that I have 80 students. That means my income is more than lakhs, my lord. That is also, that is also false projection, my lord.
He has got enough income. He goes to the school, my lord, in a Swift Desire car, my lord. That is my instruction, my lord. He is a LP school teacher. He goes to the school with a Swift Desire car, my lord. Had his income is less, my lord, he could not have do that, my lord.
But
He is
whether they have
running
proved
he's
it before the court, my lord,
that is not required.
that is
to
not
prove.
proved.
In this
Of
case,
course,
I am
in this
not
proceeding,
required to
not
prove.
required, my lord, but making some submission, because, my lord,
Let
that
him-
Swift Desire was passed before my marriage, my lord. And in that time, my lord, I was working in a venture school, my lord. I could go for, my lord, tuition, etc. I did make some money. I do not deny that. But after that, my service was provincialized. It has been prohibited by the government. I cannot go for private works or tuition, my lord. Therefore, I am in
There
a
is a circular,
destitute condition, my
They
lord.
cannot go
No,
for
but they are,
tuitions.
he is doing, he is continuing.
No, my lord, I
He is
vehemently
continuing, my lord. He is
object to that.
continuing the my lord, tutorial home. He is continuing with the tutorial home. Around 80 students are there. As per my instruction, my lord, I am submitting that, my lord.
Then in that
I
case,
have not visited, I have
my
not visited
submission, my
his
lord,
house, my lord.
although it is not relevant for this case, but I know, I understand that your lordship is trying to help me, my lord, considering my condition. Then if that is actually true, that I am having a tutor center, my lord, and that I have 80 students, if they can prove it, I do not pray for reduction of the amount, my lord. But if they cannot prove, then in that case, my case should be considered, my lord.
No, not
In this
case,
proceeding,
not
In this
my
case,
lord,
therefore I am saying,
in this proceeding, I am not required to
in
prove.
that case.
I have whatever was required to prove, I have proved, my lord.
Today I'll dispose it off. I'll
my lord,
admit.
you may give some observation to that effect, my lord,
No,
that
no.
I'll make some,
No.
make an application, my lord.
No, no.
Otherwise, my lord, out of 14,000, admittedly, I am giving 7,000, my lord. Where from I will bring the amount, my lord? And if this happens, my lord,
That also.
then
Lordship
husband
may
would not
observe.
go for marriage, my lord. Only that some amount is fabricated. This is my contention, my lord. And I believe it that it was not there. Even then, taking the plea that yes, this is in the documents, they are intending and they are, my lord, die hard to take the money at any cost. Whether she has no responsibility for the welfare of the husband, my lord. A wife has also some reciprocal obligation towards his husband, towards her husband. But she is not trying to understand that.
See, I'll not admit it. I'll call for the lower court record.
My
Lordship,
lord.
Lordship will dispose of this petition, my lord, because my lord, he is not paying the maintenance also, my lord. This amount is also is not being.
Cannot dispose of without going to the form. Where do you have the original form?
With the wife, my lord.
With the wife?
Wife, my lord.
Original application maybe with the Qazi.
Maybe.
An application is given to the
But it is
Qazi
not
for
my- it is
registration
not
of
in my
marriage, my
custody.
lord. application is given to the Qazi, my lord, for registration of marriage. And the Kabinnama is there. Kabinnama, original Kabinnama.
To decide on the copy, on a copy.
So
My
that
lord,
copy
the
was produced, my lord.
original Kabinnama is produced. Lordship, kindly produce.
I don't want a cabin number.
Page
No, my lord.
The
58.
manipulation is in the form.
Yes,
So
ma'am.
the lower court
Well,
decided that.
The
how did you
Kabinnama,
know
Yes,
that-
ma'am.
Kabinnama is signed on the date of Dika, my lord. On the
Page
date
number
of
41.
Dika.
Huh?
Xerox copy was produced, my lord. The cross-examination says, my lord.
What is the decision on that, decision of the lower court on that point?
That the observation is that since the Qazi has appeared and said, admitted that yes, I have issued. So that was enough. That was the perception.
Let me see the decision.
The
Where-
attesting
paragraph?
witnesses also, my lord, supporting my case, my lord. Attesting witnesses in the.
My lord, your lordship will
Kabin-
find at page number, my lord, page number 61, my lord. In fact, page number 60, paragraph 16, my lord. It starts from paragraph 15.
Page number 60?
60.
60. Please read.
My
Read
lord.
the paragraph.
In the cross-examination of PW3, on the basis of the defendant's question, PW3 stated that Abul Qasim was the Qazi who performed the marriage of the plaintiff and the defendant. Now, in order to prove the contents of the document, the plaintiff has summoned the Qazi Abul Kalam as PW5, who has deposed that he had solemnized the marriage between the plaintiff and the defendant by executing the Kabinnama, that is Exhibit 1, and he had put his signature in the said document, and Exhibit 1 so and so is his signature, and the bridegroom and the bride and the witnesses also put their signature. He further deposed that as per mutual agreement of both the parties, the mahar was rupees so and so, out of which the groom has paid rupees so and so, and the bride and the remaining amount was to be paid later on. The said witness has thus, this is the observation, Lord. The said witness has thus complied with the requirement of Section 67 of Indian Evidence Act, that he admitted of the issuance of the certificate, that was enough according to the perception of the learned trial court. But that cannot be, because the cross-examination, the Qazi himself has said that yes, I have seen the Xerox copy, where there is a change in the amount. Even then, the court did not call for the authentication
What
on
is the
that
suggestion
point.
regarding the application, my lord?
That is the application.
Application.
Xerox copy of the application.
This is, my lord, this is about the Kabinnama.
Therefore,
This is about the
Kabinnama was the
Kabinnama.
later document, my lord, prepared on the basis of the application, my lord. Kabinnama is the second document that is
When
issued
a marriage
based on
is
the
ex-
first document. my lord.
When a marriage is executed by the Qazi, my lord, and an application is given, on the date of marriage, my lord, the Kabinnama is signed by both the parties along with the witnesses. My
But on
friend
that
is,
day, there
my
was
friend
no
is
change, my lord.
stating, my friend is stating that the Kabinnama was, my lord, prepared later one,
Yes.
later one. It is not a fact.
This is the procedure.
Kabinnama is prepared on the date when the marriage is executed.
No,
And it is signed by himself, my lord. He
No,
himself, my lord. In the Kabinnama, my lord, there is no manipulation as asserted by my friend. And the manipulation he has alleged, the criminal case he did not proceed.
I would prove,
He
my lord,
did
that
not proceed
the
with the criminal
certificate is
case.
later on, my lord. I would prove.
Had there been fabrication, my lord, he could have proceeded with the criminal case.
No, my lord.
But the criminal case has been dismissed.
For a moment, my lord, that
On
the Kabinnama is a
What is the basis
later
of his
document.
allegation now,
I would
my
prove, my lord, from the chief of the Qazi himself, my lord. And this would go to show that the Kabinnama was prepared later on, my lord. Because he is the in charge, my lord. He was the in charge. He was not the main Qazi, my lord. So that certificate ought to have been issued by the authorized Qazi, but he was not the authorized Qazi, my lord. And he has said that I have not brought any authorization letter today, meaning thereby he was not the competent authority to issue the certificate on the date of marriage, my lord. And this is the process that on the date of marriage, application form is filled up, and according to the entries made therein, my lord, subsequently the marriage certificate is issued, that is in the form of the Kabinnama, my lord.
Lordship, kindly reappreciate the evidence of the Qazi, my lord. Page 40. Page 40. I appeared before the court after receiving the summon. I have been working as Qazi of Pub Matia. I have solemnized the marriage between the plaintiff and the defendant on 19/9/2010 by executing a Kabinnama. He has solemnized the marriage, my lord, by executing the Kabinnama, putting my signature in the said document, and also obtained signature of both the bride and groom, including witnesses. Exhibit 1 is the Kabinnama, and Exhibit 1.3 is my signature. As per mutual agreement, both the parties mohar of rupees 5,17,860 rupees only, out of which the groom paid 6,350 only to the bride, and remaining amount was to be later one. The said Kabinnama was countersigned by the District Qazi Yusuf Ali. Exhibit 1.4 is the signature of the District Qazi, which is known to me. I have not brought the authorization letter as Qazi. I have not submitted application form in respect of marriage. Both the parties submitted application form of marriage with their signature. Today I saw the Xerox copy of the same with eraser mark in the amount noted on down in the word, but not in the numerical. It is not a fact that the actual mohar amount is 51,000, but we fabricated the amount. I do not know if the defendant lodged any FIR against me, the plaintiff and her father, so and so.
Where is the issue relating to this?
Milord.
Any issue was
No,
raised?
no, this issue was also not framed, Milord.
How can you ask me to admit then?
Because so far as the issue number 3 is concerned, that is impliedly, Milord, covering this issue, Milord, issue number 3. So that is with regard to the amount, Milord. But my simple plea and the cross-examination as well as the plea.
Where is your who has brought up the title suit?
The wife, my
Wife.
Mine.
Where is your plaint?
Wife plaint.
Is WS the
Annexure
possible
1,
fine?
that is
Page
21.
42, my lord.
Plaint.
Plaint,
Plaint
page
is
21, Milord.
page 21.
21.
Issue was also not framed.
Issue was framed with regard to the amount, Milord. Whether it was 5,17,860 or not. So within that parameter, Milord, this issue also came, because our plea was that amount.
Okay, well, it can be included.
Might.
All right. Where is the plaint? Page 21.
Page 21 is the plaint, my lord.
May I read, Milord?
Yeah, you can read
My lord.
from the beginning.
Yes, Milord, page 21. That on 19/9/2010, the marriage of the plaintiff was solemnized with the defendant as per Muslim religious right and custom by executing a kabinnama fixing mohar at the rupees so and so. At the time of marriage, defendant paid 6,350, keeping rupees 5,11,000 so and so as balance. After marriage, the plaintiff started her conjugal life with the defendant at the house of the defendant. That after 6 months of plaintiff's marriage, the defendant demanded rupees 2 lakhs for construction of the dwelling house. Expecting a happy conjugal life, the father of the plaintiff paid the demanded amount of rupees 2 lakhs in cash to the defendant. After receiving 2 lakhs from the father of the plaintiff, the defendant again demanded one Maruti car and cash rupees 1 lakh from the plaintiff. But plaintiff refused to pay the same. As a result, the defendant started torturing the plaintiff both physically and mentally. That on 30th/12/2012, the defendant, along with his family members, inhumanly assaulted the plaintiff and driven her out from the house of the defendant, causing grievous injury. Finding no option, the plaintiff took shelter at her parents' house, provided that at the time of driving out, the plaintiff was pregnant and later on a male child, namely so and so, was born at her parental house, who is presently 6 years old. That after driving out of the house of the defendant, the plaintiff made several attempts to resume her conjugal life, but the defendant and his family members did not allow the plaintiff to do so. Since 30/12/2012 till today, plaintiff staying at her parental house with her minor child. After driven away, defendant neither visited the plaintiff nor provided any maintenance to the plaintiff. As a result, plaintiff filed MCR case number so and so for monthly maintenance, and accordingly, the Honorable Court directed to pay rupees 1,500 as monthly maintenance for the petitioner and for the minor child. But presently, the said amount is insufficient for their maintenance. That at the time of marriage, mohar was fixed at so and so, and defendant paid rupees so and so. The balance is rupees so and so, but till today, defendant has not paid the unpaid mohar amount of rupees so and so. That plaintiff verbally requests the defendant for several times to pay the unpaid mohar. but the defendant did not pay heed to the request of the plaintiff. On 15/6/2019, again the plaintiff requested the defendant to pay unpaid more amount of rupees so and so, but the defendant refused to pay the same.
Where is the WS?
WS, your lordship will
Page
find at page
42.
number 42, my lord. Page 42. Married. That the suit is not maintainable in the present form and manner as the suit is declaratory. Plaintiff could have filed money suit. That there is no cause of action for this suit and as such it is liable to be dismissed forthwith. That the defendant denies the contents of all paragraphs of the plaint except those which are specifically admitted herein. That para number 1 is partly admitted and partly denied by the defendant. Marriage is admitted, but the more amount of rupees so and so
Okay.
is denied.
Okay.
My lord.
So let's go to the judgment of the lower court.
My lord. My lord, this judgment your lordship will find is number 51 onwards. My lord. Then page number 52, my lord. Married, my lord.
Not the entire judgment is not required.
Yes, my lord. This suit is filed by the plaintiff praying for.
No, not required.
My lord.
I'll read it. I'll read it. The required portions, I'll read it.
My lord.
Indian
You can sit down.
My lord.
Did you exhibit page 66?
But it was Xerox copy, it could not have been exhibited, my lord, because I did not have the original copy, my lord. That just the Xerox was produced. Therefore, I could not. But it was supposed, the trial court was supposed to
See, I'm
direct.
telling you that witnesses have proved that the cabin number was executed on that day.
Then in that case, my lord, if it is admitted, then whether the,
No, we'll not admit.
no, my lord,
We'll dismiss
no,
it.
the fact, my lord, the fact of issuing the cabin number on the date of marriage, my lord, if it is, this fact is admitted, whether that main Qazi, who was the, because he was just the helper, my lord, the Qazi who
is not
appeared,
required.
but that Qazi who could have originally issued, he was not, he was not present, my lord.
Evidence Act of CPC contest. The persons who are present at the execution of the document is required. That main Qazi is not required.
Therefore, my lord, but he has said that I have not brought the Xerox copy of the, I have not submitted any marriage application form. If he has not submitted any marriage application form, then how could he fill up the, my lord, the entries or the information in the certificate, my lord? So this appears to be contradictory, my lord. And if this Kavinnama was issued on the very day, my lord, then the issuing authority.
Why are you going back to the marriage application form?
Because fabrication was there, my lord. There for me. Otherwise, I do not. I also understand that I do not have any case, and I pleaded it repeatedly before the learned trial.
You ought to have produced secondary evidence at the stage of trial.
Of course, that could have been done, my lord, but that was not done, my lord. I also admit. But that was my consistent plea. If it is on record that the Xerox copy is there, and he also admitted that yes, there is some eraser. So that part ought to have been ascertained, my lord. What compared them or what inclined them to make the sense? There is no explanation to that effect.
In that case, my lord, he is a teacher. He should not have signed up Kabinnama, my lord. Kabinnama, it was the amount claiming by the my lord, wife that is written in the Kabinnama. He has signed that Kabinnama. He is a teacher. He is not that he is an illiterate person. He does not understand Assamese writing. It is not that, my lord. He has signed that Kabinnama.
My lord.
Seeing all the entries. After that, only he has signed.
And witnesses have proved it.
Yes, my lord.
Of course, that observation is there, my lord. But that my grievance was that, my lord, I placed it before the learned trial court, but to that effect, the ascertainment was or determination was not there. So if that part your lordship considers, then I have a case, my lord. Otherwise, I also admit, my lord. And the fact that the Qazi himself has said that there are some sales, and that the Xerox copy was there on record. Therefore, it was incumbent to ascertain whether there was manipulation or not.
This case was under
CPC, my lord.
There's a parallel provision, my lord, under the
They have not, my lord,
Marriage
made any
Protection of
provision.
Rights on Divorce Act, my lord, 1986. That is section 3C, my lord. 31C. And the application is to be filed under section 3B.
And that plaint is at page 21.
Page 21.
My lord, page 21.
Page 21, no?
31C and 3B.
31C and 31B.
3B.
3B. Have you mentioned you have filed for divorce?
No, my lord.
He has filed for divorce?
No, nobody has. My lord.
No,
So
no,
this act would not apply, my lord, because it applies to the divorced women, my lord.
only relating to Mohar.
My lord, they have not mentioned any provision also, whether it is under CPC or it is under, my lord, the Dissolution of Muslim Marriage Act. Because this act applies to the divorcee, my lord.
Page 21 is the plaint, no?
Yes, my lord.
But in that case, this act will not be applicable as the divorce is not solemnized. It has, the marriage has not been dissolved, my lord.
The
Marriage is not dissolved.
No, no, my lord.
Till today, my lord. He has got married for the second time. I am still, my lord, not married. That act will not be applicable in this case.
Suit for declaration and relation of unpaid Mohar.
My lord. Simply
This is, my lord, under the Mohammedan law, my lord. It has been quoted in the judgment itself, my lord. Page 57, my lord. Page 57. It has been quoted, my lord.
This is getting complicated now.
Under this act, my lord, only at the time of dissolution of the marriage, my lord, she can apply my lord, under this act. But my lord, if the application is not filed under this act, my lord, she can claim under the CPC also, my lord, under the Mohammedan law, my lord. It is not that she cannot claim.
Mohar before dissolution of marriage.
Yes, she can claim. It should be paid, my lord, before, my lord, consummation of the marriage, in fact, my lord. The mohar is an amount, my lord. This should be paid to the wife, my lord.
And even after the marriage also.
Yes,
it
ma'am.
That can be
paid.
done.
Yes.
It is.
The divorce is not mandatory.
Divorce is not mandatory.
No, it is admittedly not.
But
But even if that they ought to have mentioned under which provisions they have come. Otherwise, because there are some questions relating to law also. If the provisions have been mentioned, then in that case, the question of limitation or other things also comes up. But that they have not mentioned that. Therefore,
no, but it has
of
been
course,
explained by the trial.
my
court.
lord,
My lord.
How that mohar can be.
My lord.
But now, when it is a suit, then
It was a suit, my lord.
should you come as a suit for okay? You can come for revision. Yes.
Revision, because there is no provision for appeal, my lord.
Amount of mohar is the property under the, my lord. She has to, the wife is entitled, my lord.
Yes, yes.
My lord. So, my lord, she has, my lord, claimed the property of, that is her entitlement from
Yes,
her
yes.
husband, my lord. Under the
This has been explained in the judgment.
in the judgment, it has been explained, my lord, in 57 also, my lord, page 57, 58. So, my lord, there is no bar in, my lord, deciding the claim, that the title suit by the Nanad court below, my lord.
Correctly decided.
My
My lord, I have not disputed that also.
Under the Protection of Muslim Women on Divorce,
So
my lord,
this
act.
was not filed under this act.
No,
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 ma'am.
You don't know again.
this is wrongly. Because under this
That
act,
will
my
not-
lord, after divorce, my lord, after divorce, and a Mohammedan
Yes.
wife cannot file an application under section 125 CRPC also,
Yes.
my lord. This is there is a perimeter provision under this act.
Yes,
my lord.
yes.
My plea, with all respect, my lord, since that copy of the application is part of record, my lord, before disposing this proceeding, my lord, may I pray that, my lord, at least this honorable court may have a look if the record is called for, my lord.
Plus, his the duty to bring that on record, my lord, in the trial court. He
No,
could
the-
have,
it
my
was
lord,
not in my
he could have
custody.
called for, he could have called for the record, my lord, from the Qazi. He
So
did not.
here
do
you're
that.
not revision petition. That's why I'm taking up this review. Not in revision petition. I don't think so.
I leave it to your lordship, my lord. Otherwise, I am also in a destitute condition, my lord. I'm the husband. My meager amount is income is, my lord, 14,000. Even if I'm fighting hard, my lord, the area amount, in one installment, my lord, 40,000 I have paid. And very shortly, my lord, I am also paying the 40,000 with regard to the area of maintenance, my lord. And if again this burden comes,
Agency you're paying 7,000 per month.
yes, my lord, I'm paying, my lord.
That I have submitted that around 3 lakhs, my lord, are pending.
It is not 3 lakhs,
is
my lord.
not-
My
he is
instruction is
not-
2 lakhs around.
he is not
Anyway,
saying that
I am paying, my
one-
lord, one installment. That court has allowed me, my lord, to give it on installment, my lord, and I am paying, my lord. One installment is given 40,000 in addition to the regular amount, my lord, and second installment I am paying shortly, my lord. I am trying my best, my lord, sir. I am not that, I am not complaining to the order of the court passed, court, my lord, passing the order.
That's why I asked, gave
My
you
lord.
2 dates to settle the
Because
matter.
that, my lord, the order is in their favor, my lord. Now they are
I
a little
have
bit
a son,
adamant.
my lord. I have a son, my lord. He is studying in class 7. I have to look after the son also, my lord, not only me. He has married, my lord. He has got a wife and children separately, my lord. But my son, my lord, how can I maintain? I have no, my lord, source of income.
So my instruction, my lord, she is also doing a teaching in a private school, my lord. But that I have not placed before this court because this is not relevant in this proceeding. Otherwise, allegation and counter allegation would be there. There she has a daughter. She has a son. I have also a daughter, my lord. Therefore, the amount is 50-50, my
son
lord.
is his
Out
son
of
also.
14,000, 7,000 I am paying him and
He should not
7,000 I am
forget that,
using
my
for
lord.
me.
My son is his son also, my lord.
Therefore, you are saying that I have a son. Then you ought to have referred that we have a son, my lord.
Let us call for the record then.
My lord.
But only the record, I
My
call
lord,
for the record only.
My lord.
Because here 115 in the first sentence is the High Court may call for the record.
My lord.
So let us call for the record.
My lord.
Now, keep the matter as part heard, my lord, and after record is
After
received,
record, I'll.
receive, my lord.
I'll
Process
file.
will this one.
Can be, but if I'm not around, then it will take some time.
No.
If I'm not around,
I have
if
no
I go
objection.
to some outstation, go to
Mine.
some outside location, so it will be difficult. Why didn't we call for record earlier?
Actually, my lord,
Because there was a delay, my lord. I was fine.
Lordship
For-
wanted
for-
to dispose of this matter today, my lord.
That is why.
My lord.
Records are not required actually.
Actually, in this case, my lord, everything is there.
For-
Everything has been annexed by my friend,
We
my lord.
call for record of any case which has been decided.
Yes. It is not, my lord,
Not
necessary.
required.
Lordship may or may not. And everything is annexed by my friend in the, my lord, CRP, my lord. He has annexed the documents.
Dictation.
My lord.
Let's see how far we can go.
My lord.
Third Learned Counsel, Mr.
A. Ali.
Number kiman hoy?
8.
I'm A. Ali.
নাম পার্টি বিলাকৰ নাম লিখিব নোৱাৰিব খালি দেই Third Learned Counsel Mr. A. Ali for the petitioner X petitioner hyphen say petitioner comma say hyphen X and Learned Counsel Mr. I.H. Soikia for the respondent okay say comma di say hyphen Y.
Husband को भी लिखा पड़े नाम तो नहीं लिखा
It is submitted on behalf of the petitioner that the petitioner is a tutor working in a provincialized school and he has a fixed income of rupees how much?
14,000, my lord.
Which
Fixed.
page? Which page?
My lord, it is at Santal, my lord. The name of the school is.
No. From your petition.
Oh, my lord, no, I produced one salary statement. My lord.
Okay, then it is not required.
And then annexure 1 was also their provincialization order. My lord.
Fixed pay I have in paragraph 2. Fixed pay of rupees 12,600 per month.
As on date, my lord, it is 14,000. Initially, it was 12,600.
Within bracket, at present 14,000
Might.
per month, bracket close. It is submitted that now the petitioner is burdened by the demand of the respondent Y, who has demanded the mohar fixed at rupees 5 lakhs. How much?
5,17,860.
5,17,860.
My lord.
5,17,860. Full stop. The petitioner is at present paying a monthly maintenance of rupees 7,000 per month to his wife. He has his own family
60.
and he is unable to meet the expenses of both the families.
Yes, yes.
Full stop. It is, the petitioner is aggrieved as the mohar was manipulated while filling up the format for Kabinnama, for format of marriage and Kabinnama. Full stop. The mohar was enhanced from rupees 51,000 to rupees 5,00,000 17,860. The cross-examination of the Qazi is PW how much?
Is number 41 the cross.
PW 5, my lord.
PW
5.
5, page 40.
Five reveals that the amount in words was manipulated, whereas the amount in figures remained the same in the format in the form which was filled up to register the marriage or the register the Kabinnama. Full stop. The petitioner has thus prayed to set aside the order passed by the learned trial court in TS number
19 of 2019. 19 of 2019.
19 of 2019, wherein by judgment and order dated
23/9/2024.
23/9/2024, the petitioner was directed to pay the dower stroke moharana of rupees 5,11,510. No? This is the order. Although you are demanding 17,000, but
Because the
as you
same amount
pay
was given.
6,000. Per contra, learned counsel for the respondent laid stress in his argument that the format, so-called format, alleging manipulation of the amount of moharana in words was not produced as evidence during trial. Full stop. The argument of the learned counsel for the petitioner that the Kabinnama was signed later on by the
PW5.
By the attesting witnesses as well as by the parties and the Qazi cannot be accepted, as the evidence of all the witnesses clearly reveals that the Kabinnama was signed on the date of marriage. Full stop. It is further submitted that the respondent or that the petitioner, being a teacher, was well aware of the amount of moharana fixed at the time of signing the Kabinnama, and he could have easily refused to affix his signature. Full stop. Now, at this stage, when he has been directed to pay the when the petitioner has prayed for payment of the entire moharana, entire mohar, it will be better addressed as mohar, no? Instead of moharana.
Moharana is also appropriate.
Huh?
Moharana is also correct.
But what is a better spelling?
Mahar.
Accepted spelling?
It is M-A-H-U-R.
M-O-H-U-R. Internationally accepted spelling? M-O-H-U-R. Comma, he has he through his written statement has falsely alleged manipulation of the Kabinnama. Full stop. Manipulation of the form, not Kabinnama. Manipulation of the form. Full stop. As this it is further contended that that no criminal case has been brought up against the Qazi as well as the bride's father,
My lord.
who allegedly
Well, one
Collusive.
file that was dismissed. This is the order.
it is submitted that the criminal case which was brought up against some Qazi or
Yeah, Qazi and the parents and as well as the respondent
which was brought up against the Qazi, the respondents,
and the
as
father.
well as the bride's father, was dismissed as no materials could be found against the arraigned, ARRAIGNED, arraigned accused to proceed in a case alleging forgery and manipulation of documents. Full stop. It has been held by the learned trial court that you are not disputing the procedure of demanding the Moharana. You are not disputing, no?
Disputing, my lord.
Disputing?
Oh, yeah.
That is
No, my lord, to that effect, that was rightly decided, I think.
So what is your prayer now?
Prayer to be prayer to you.
Oh. What's the deal? Let aside. WS of the?
It's 11. That's 11.
Rounds.
The learned trial court has held that
17 was a fair.
not disputed.
My lord.
It's 16.
মাটি দেচোন 5 মিনিটৰ পিছত আহি বাকীখিনি হেৰি কৰিম। It will take me 10 minutes. I'll come back. It will take, after coming back, it will take me 10 minutes to complete the dictation.
Well,
No, not you.
my lord.
I'm addressing
My lord. My lord.
the learned counsel
My lord.
behind you. It will take me 10 minutes. You can do some other work and come back. Has been held by the learned tribunal, Lizano. The issue number 3. Which includes the petitioner's plea was elaborately discussed by the learned tribunal. Full stop. It has been held by the tribunal by the learned trial court. Full stop. It has been held by the court that the document exhibit 1 is the foundational document relied upon by the petitioner as well as the respondent, thereby or respondent, full stop, the document was exhibited, thereby satisfying the requirements of sections 61, 62, and 64 of the Indian Evidence Act 1872, within bracket the Evidence Act for short bracket close. Full stop. It was observed that section 67 of the Evidence Act deals with proof of signature and handwriting of person alleged to have signed or written the document produced. Full stop. It was held by the trial court that the plaintiff exhibited her signature and the signature of the defendant, plaintiff stroke respondent likhi diba, huh? Exhibited her signature and the signature of the defendant stroke petitioner as exhibit 1 within bracket I small I 2z within bracket 1 and exhibit 1 within brackets I duta small I duta 2 on the original document full stop. In her cross examination, PW1 stated that the amount of rupees 5,71,000 5,17,860 was written by the Qazi in her presence, and Idris Ali, Kubat Ali, Bilal Hussain, and Monul Haq were present at the time of the execution of the Kabinnama. Who stopped? Kubat Ali, SPW3, and Bilal Hussain, SPW4, have substantiated the evidence adduced by the respondent stroke plaintiff. So it was further observed by the trial court that the cross-examination of the PW3, Bilal Hussain, on the basis of the defendant's question, depicts that Abul Kalam was the Qazi who performed the marriage of the plaintiff and the defendant. Full stop. The Qazi SPW1 has testified that he has solemnized the marriage between the parties by executing the Kabinnama, Exhibit 1, and he had affixed his signature on the document and has proved his signature as Exhibit 1 within bracket 3 small I tinta di diba. PW5 further stated that the bride and the groom were also witnesses, were also present and they have affixed their signatures on Exhibit 1. As per mutual agreement between both the parties, the mohar was fixed at rupees 517,860, out of which the groom paid rupees 6,350 to the bride on the same day, and the remaining amount was to be paid later. After discussing elaborately the evidence of PW 1, 3, 4, and 5, it was held by the trial court that the witnesses have complied with the requirement of Section 67 of the Evidence Act It has been observed, it has been held by the Honorable Supreme Court in Narbada Devi Gupta, Narbada, N-A-R-B-A-D, Devi Gupta versus Birendra Kumar Jaswal, reported in AIR 2004 SC 175 that colon dipla hyphen di diba, within inverted commas or italics of di diba. The legal position is not in dispute that mere production and marking of a document as exhibited by the court cannot be held to be a due proof of its contents. Stop. Its execution has to be proved by admissible evidence, i.e., by the evidence of those persons who can vouchsafe, vouchsafe, vouchsafe for the truth of the facts in issue, inverted commas closed. The decision of the no infirmity, the decision alage next prayer here, no infirmity is would be decided, no infirmity the decision of the learned trial court does not suffer from any infirmity. Full stop. It has been correctly held that the exhibit 1 has been duly proved. Full stop. The learned counsel for the petitioner has drawn the attention of this court to the cross-examination of PW5, which has also been discussed and discussed elaborately by the learned trial court. Full stop. PW5 has denied in its cross-examination that page 61, no?
41, madam.
Page
Page
41.
41.
That the Kabinnama was fabricated. Full stop. He has admitted that the form of the marriage, the photocopy of the form of the marriage reveals an eraser mark in the amount noted down in words, but there was no manipulation in the numerical amount of the muhar. Full stop. The petitioner has also submitted that an FIR was registered as Motia PS case number 29/2022 under section 420, 468 of the IPC against the Qazi as well as the Qazi, the bride and her father. But it is admitted, it has been admitted by the learned counsel for the petitioner that this case was dismissed. Full stop. The petitioner has stressed upon the manipulation of the amount in the pro forma for pro forma required to be filled up by the parties to solemnize their marriage, which has to be registered in the form of a Kabin Nama, KBIN, huh? Kabin Nama. File italics of Kabin Nama. It is submitted that as the amount of Moharana has been manipulated and increased to 5,17,860, and as the petitioner is already paying rupees 7,000 per month out of rupees 14,000, he is being burdened by the unjustified demand of the respondent. Stop. This format, which the petitioner has claimed to have been manipulated, and the Moharana increased through this format, has not been produced as evidence. So it is submitted that the original of the format is not available with the petitioner. This submission of the petitioner can be safely brushed aside as the document on which the petitioner has relied, as a document which forms the basis of the case of the petitioner, has not been produced. Even as secondary evidence, Although plea was taken in the written statement that the amount of rupees 517,860 or amount of rupees 51,000 has been enhanced fraudulently to rupees 517,860. Yet, the petitioner has failed to prove these allegations true. Through the evidence adduced by the petitioner, the evidence of DW2 cannot be considered as DW2 was not a witness to the execution of the Kabin Nama, In view of the foregoing discussions, it is thereby held. In view of the foregoing discussions, I record my concurrence to the decision of the learned trial court, and thereby this revision petition is dismissed as the petition is devoid of merits. Very sorry.
My one observation may be recorded below. That with regard to the submission by the other side, that being a teacher, after knowing everything, I put my signature.
I have recorded.
No, my lord, my objection to that at that time amount was not fabricated, therefore I put my signature. So that may kindly be recorded.
Why are you agreeing that amount was not fabricated? Why don't you go for appeal against my order?
Obliged, my lord. I'm obliged, my lord.
It was on quantum, but I think my friend is not interested for mediation, Lordship. So you can go for hearing, Lordship.
Learned counsel Ms. Adi Mozumdar is present for the insurance company, and learned counsel Mr.
A. Hussain, Lordship.
A. Hussain is present for the
Respondent number 1.
claimant.
Claimant
For the claimant, respondent number 1, and has submitted that there is no element of settlement.
No, Lordship, there is element of settlement, but Mr. Hussain is not interested to go for mediation
Lordship-
because it is on quantum only. So, but if party doesn't want Lordship, it cannot
It's
be
not
said.
willing that and submitted that the claimant is not willing to proceed with the mediation. List this matter for
End of the March, Lordship, 26, Lordship.
we have the documents and parties are all present.
Yes,
No,
service
already
completed.
completed. Last
Is
of
this
the
matter for
was-
hearing after 4 weeks?
Lordship fixed a date just.
Okay.
And the
2020 matter, 23 matter.
Lordship, and on 26 March, Lordship. and-
Okay, for hearing on 26 March, yes.
Highly obliged.
March.
I'm sorry, Lordship, I was in good.
No, it's okay. এইটো লাষ্টত গুচি গ'ল নেকি তাই এটা ৱৰ্ড এটা চেন্টেন্স এটা নো কষ্টৰ কাৰণে এটা লাইন এটা লিখি গ'ল কৰি আছিলে নো অৰ্ডাৰ টু কষ্ট বুলি এটা লাইন লাষ্টৰ লাইনটো য়েছ
My lord, this matter was listed on my prayer, my lord,
Ah.
because the principal respondent number 2
Ah.
expired on 17/12/25, my lord. This is just for intimation to this honorable court, my lord.
Respond number 2. So you have the details of the legal yes?
I'll have to ascertain.
Huh?
I have to ask my client.
Yes, yes, okay.
I furnished him the details earlier, my lord. Again, I will furnish him the
Okay, all right.
legal names of the legal heirs. I will furnish.
Today only I came to me.
Okay. Learned Counsel Mr. A. Dhar is present for the claimants. For the applicants.
Appellant.
And Learned, you're sending counsel.
No. I am
Learned
the
counsel
respondent number 1 and 2.
Kavita.
Yes.
Your name?
TC Das, my lord.
TC Das is present for the caveator.
Respondent number 1 and 2.
For the rest, nala caveator nala. Respondent number 1 and 2.
2.
Principal
respondents may be written, my lord.
For the principal respondents and has submitted that the respondent number 2 has passed away.
Yes.
Who's
On
the-
17/12/25.
Respondent number 2 has passed away on 17/12/2025. Full stop. The legal heirs may be arrayed. Legal heirs may be impleaded. List this matter after
After 2 weeks.
2 weeks.
Yes.
Obliged. This is a close session for enhancement.
Lordship, notice may go in the cross appeal and they have served us copy directly. We will take instruction from the insurance.
Cross objection for enhancement.
First, at the top is cross objection,
But that
21.
when is the next date fixed for the appeal? Same date will fix it.
No, that is also there, Lordship. MSC Appeal 280 of 2025.
Okay, okay. Learned Counsel Mr. M. Khan is present for the
Cross objector.
Objector list for issue. Learned Counsel Miss R.D. Muzumdar is present for the insurance company.
Yes, Lordship.
Notices to be issued to the other respondents. Full stop. Copies to be furnished. List this matter after 4 weeks.
Yes, Lordship.
And
To
notice to
the other
respond-
respondents returnable with
respondent 2 to 4. 2, 3 and 4.
Huh?
2, 3 and 4 respondent.
Yeah.
Sub. No.
You will issue notice.
Hello?
2, 3 and 4 you will issue notice.
Yes, number 1, Lordship, she is appearing and remaining.
Other respondents I have mentioned.
And to us, extra copy may be given because
Yes,
they gave us
to be punished.
extra data. You have to debug instruction law. Highly obliged.
May I please, Your
Mm.
Respondent 3 and 4 has appeared, Lordship. And 1 and 2, Lordship, they are no longer surviving, Lordship. They have expired, Lordship. So I may be allowed to increase their level as
1 and 2. Learned Counsel Mr. J. Kolta is present for the petitioner. And Learned Counsel Mr.
MH Soike, my lord.
M.S. Sokia is present for respondent number
3 and 4, my lord.
3 and 4. Full stop. It is submitted by Learned Counsel for the petitioner that the respondent number 1 and 2 have passed away. and he may impede the respondent, the legal case of the respondent. List this matter after 2 weeks.
2 weeks.
2 weeks.
It may be, there is the interim order that may be.
Interim order shall remain in force till then. Date of the direction. List this matter on 23rd February.
Copy may be given to us, my lord. We have not
So
received.
copies to be furnished to the
number three.
respondent number 3 and 4.
Obliged, ma'am.
My lord, in this case, I am the respondent in the appeal. I have filed an application for injunction. Here in this case, my lord, the trial court suit for specific performance of contract was decreed. Against that, they prefer appeal before this honorable court.
IS for?
I for injunction, my lord.
For injunction, okay.
Yes.
What have they done?
They are started construction because.
No, my lord, we have done nothing.
Yes,
because-
then that may be recorded and that order may be passed. I have.
Because we have been, the conditional stay was given, we have been asked to file an undertaking by an affidavit before the registry, and we have done that, my lord.
No, that was done by the legaliers of the present
No, my lord.
opposite party.
That is not correct.
Now the legaliers has come, my lord. My averment is that after death of the original appellant, the legaliers started construction.
Since there is an already stay, my lord, they have to file a violation of the injunction, that order. They have filed an now seeking injunction.
Yes.
There's already a stay, I think.
Yes,
No,
yes, yes.
they have filed an appeal. In appeal, suit for specific performance of contract was decreed. Against that, there was an stay. Against us. Now, they are started construction.
We have not, we have
No,
done
when
nothing.
there is a stay, it will serve the purpose, no?
My lord,
Don't serve.
it will not serve because why it will not serve? I have filed a suit. My suit was decreed.
Specific performance
So contract was
contract.
decreed. That was stayed.
Okay.
So injunction is required, my lord.
No, my lord.
Otherwise, the third party right will be created.
No, my lord,
All these things.
my lord, kindly see the
My-
order passed on 27/11
Suit for specific performance contract.
27/11.
2019.
27/11/2019, where? In
Uh,
RFA.
Yes, my lord.
27?
11/2019.
Okay. You are the appellant?
My lord, yes. As an interim measure, my lord, first, second, third, fourth paragraph. As an interim measure, the execution of the impugned judgment and decree referred above is state subject to condition that appellant shall not sell, mortgage, lease, or otherwise encumber the suit land in any manner till disposal of
Where?
the.
In RFA 123?
Yes, my lord.
There's no such order as an
Yes.
interim measure?
While admitting the matter, my lord, 27/11/2019.
The appeal is admitted for hearing. By this appeal, call for the records, issue notice, the appellant shall take steps. RFA
Sorry,
one-
sorry, my lord. Sorry.
My lord,
In the IA.
Most possibly, it was passed in IA.
IA, 3992, my lord, sorry. 27/11.
Okay.
As an interim measure, the execution of the melody will find that.
So the suit is under whose possession?
Property.
Property,
Property
in our-
under whose possession?
in our
Whose
possession.
Property,
In their possession.
in your possession?
Yes.
Yeah.
We have given an undertaking to that effect, my lord. We have filed an affidavit to that
No,
effect.
no, my lord, may I point out, my lord, that order was passed when the appeal was filed. In the meantime, appellant died. They have not filed any application. My averment in this IA, they have not filed any application, it was abated. Then we filed an application that either suit may be abated or injunction may be granted against the legaliers. Then they have come up with the application for substitution, abatement, and setting aside all these things. That was allowed. Now, in place of original appellant, the present they are now into the steps into the shoe of the original appellant.
So
Now-
that same order will lie against them.
Yes, that order will, that is my prayer, my lord.
We have not constructed anything, my lord.
That may be recorded and order may be passed. That
Yes.
legal yards will be binding on the order passed by the earlier order.
It goes without saying
Because-
also, my lord. We have to
because-
comply with the order. my lord.
Because my abandonment that after death, the legal yard started construction and they are trying to create third party interest.
Learned Counsel, Mr. IA, no?
IA.
IA number?
2705.
2705.
IA 2705.
Learned Counsel, Mr. SK Ghosh is present for the applicant. And learned
I am
Applicant
SK Chakraborty for the opposite party.
Respondent in the original appeal.
applicant, stroke respondent,
In the
and
or-
learned senior counsel, no?
No, no, my lord, I am SK Chakraborty.
Oh, learned counsel, Mr. SK Chakraborty is present for the
Opposite party appellants, my lord.
opposite party, stroke appellants. This application is filed under section 151 of the CPC. With allegations that the legal heirs of the appellant have, the original appellant have started construction over the suit property to the disadvantage, to the detriment of, to the detriment of the applicant. Full stop. The learned counsel for the opposite party stroke appellant. Not appellant, no?
Appellant, man. Opposite
Not
party, we are appellant.
Opposite party stroke appellant has, however, denied that any construction has been made over the suit property. Full stop. As by order dated 27/11/2019, comma, the appellants have already been directed to
Not to sell mortgage lease.
has already been directed not to sell, comma, mortgage, lease or others encumber on the suit, encumber the suit property in any manner till disposal of the appeal, comma, it appears that a status quo, if maintained, will meet the ends of justice. Okay.
No, no, my lord, we'll be bound by this order. only. And to that effect, we have already filed an affidavit. My lord will kindly see, the
Now,
applicant shall file an.
Status quo has already been passed, will likhite full stop at a deal. Pass it on. It is also submitted that the appellants, stroke opposite parties are bound by this order dated 27/11/2019, and they have already filed an affidavit to this effect.
Yes,
Thereby, those status quo is not required then.
yes, my lord.
Construction, there was.
No, nothing, my
not
lord.
to
These are the
eliminate
things.
all these
And
things.
my lord, if my lord is saying only mere statements are made, nothing is,
Affidavit has been submitted, affidavit filed by an advocate.
yes, my lord.
We'll
My
have to
lord,
believe.
My lord, here in this case, kindly see the interim order, not to alienate all these things. My specific case is that the legal years started construction.
There is nothing on record to show that, my lord. Only mere statement, my lord.
Their submission be recorded that
Yes,
they
my
have
lord.
not started any construction. Then what purpose, is this status quo as on today?
We are bound by the order dated 27/11. Already there is an
No,
order.
There was no regarding restraining of construction, my lord, is not there.
My lord, we are bound by that. Okay, if they want, we'll file a detailed objection to that only. We'll file an objection then. My learned friend said my submission may be recorded that we have not constructed anything and the matter may be closed. To that action, I have no objection. But if they want in details, then I will have to file an objection. I will file an objection to that IA, my lord.
What do you say?
My lord, my simple prayer is that status quo as on today may be maintained.
Yes.
Nothing else.
Yes.
It is further submitted that the opposite parties will file a detailed objection.
Okay, we'll file. ma'am.
We'll file a detailed objection. Full stop. Till then, till the filing of objection, status quo to be maintained by both the parties.
Yes.
Status quo be maintained as on today.
With respect to the suit property.
Status quo with respect to the suit property to be maintained as on today.
After 4 weeks, my lord. Any date
At least
after
after 4 weeks.
Madam.
Please, your lordship. My lord, here we are telling the judgment that is at page 137. It starts from 137.
One
137. After the learned civil judge senior division.
You are agreed by this judgment?
Yes, my lord. May I read, my lord? The plaintiff instituted the suit for compensation for defamation, for libel and slander. That the plaintiff hails from a very renowned family and her husband is serving in Assam Civil Services, and she has also she was also the senior grade assistant professor and was also holding the post of principal in charge of Kachar College, Silchar. That she has an unblemished record of service. Her husband is a senior SCS officer and holding the post of additional deputy commissioner, Kachar. That being a female Manipuri community, she is well reputed as a social worker. Besides being IC principal of Kachar College, Silchar, she has had a long, nearly 34 years of unblemished service, and by virtue of the same, she was holding the position both in the society and in the college principal's fraternity. That the defendant is the retired principal of GC College, Silchar, and presently practicing as an advocate in Silchar Bar Association, Silchar, Kachar. He is also the president of the governing body of Kachar College, Silchar. It is averred that as a president of the governing body, he has no role to play in his individual capacity, but jointly with other members of the governing body. All actions of the governing body must be done in the form of resolution of the members of the governing body. That the defendant, by addressing a pamphlet without any date, probably sometimes in the month of May 2016, addressing to the respected members of the Kachar College family without marking the same with confidential, restricted, secret or any other such grading, circulated the same to the general public. Captioned simply as respected members of Kachar College family, and also endorsed copies of Education Commission, Government of Assam, DA and DHE Assam. It is also contended that on receipt of the said document, followed by many other letters as stated by the Director of Higher Education received from the defendant, the Director of Higher Education Assam, by this letter dated 12th May 2016, called the plaintiff, the defendant, to attend his office chamber on 25th May 2016, along with 2 numbers of GB members, Mr. So-and-so. The matter was accordingly discussed at length, and finding no fault on the part of the plaintiff, no further action was taken. That when the defendants such false and fabricated communique mark pamphlet could not yield any vested interest of the defendant again by another pamphlet similarly undated, probably in the month of January 2017, addressed to Honorable MP Silchar constituency, sent and circulated another pamphlet by endorsing the copies to all and sundry, including the Commissioner Higher Education Assam without marking the same with confidential, restricted, secret or any other such grading, circulated the same to the general public, captioned simply as subject Kachar College scam and scandal 2015-16. That in that document too, the defendant has written highly derogative, defamatory and false statements which are in the detail contained in it, and for the sake of conciseness and brevity, the same are not reproduced. That the Director of Higher Education Assam on receipt of document 2 by letter dated 19 January 2017 forwarded a copy of document 2 and directed the plaintiff to submit a detailed report on the matter. The letter was received by the plaintiff on 6 February 2017 and accordingly the plaintiff submitted the detailed report to the Director of Higher Education Assam. On receipt of document 2, the Director of Higher Education Assam visited Kachar College on 20th March 2017 and took stock of the situation of the college and allegations made by the defendant and opined verbally that he found everything satisfactory against the plaintiff. However, on his return to his office, by the letter dated 23rd March 2017 directed to show cause alleging that 41 numbers of faculty against non-sanctioned posts to run the morning shift. The same show cause notice has been received by the plaintiff on 24th of March 2017 and according that the plaintiff submitted the reply to the show cause notice. That such activities and false allegations by the defendant in document 1 and 2 were verbally made to the Director of Higher Education Assam on various occasions and are highly defamatory, lower the plaintiff to the estimation of the higher education authorities and other right-thinking persons in the vicinity. So, my lord, here, my lord, what happened? Because of this pamphlet, my lord, the appellant was suspended from service, my lord. So, and subsequently, nothing was found against her. And accordingly, she was reinstated, my lord. She was reinstated honorably and she completed her service career and she retired. So, my lord, your lordship may kindly see the issues, my lord. Issues at page. At page 148. Based upon the pleadings of the parties, my learned predecessor in the court had framed the following issues. Whether there is any cause of action for the suit. The plaintiff has adduced her evidence as PW1 and she has been cross-examined by the defendant side at length. The plaintiff side has also submitted certain documents in this suit. Defendant side has, however, not adduced evidence of any witness. Defendant side has also not exhibited any document. I have heard the arguments of learned advocates for both sides. I have also meticulously perused the case record and the evidence on record. My issue-wise decisions are as follows. That is issue number 1. Cause of action is the bundle of facts necessary to prove by plaintiff in order to justify his claim or decree relief. He claims on perusal of the pleadings of both the parties, it is seen that the plaintiff's assertion of facts have been denied by the defendant and the same definitely gives rise to a cause of action in respect of hence I find that there is a cause of action for the suit. The issue number 1 is decided in affirmative and in favor of the plaintiff. Then issue number 2, whether the suit is maintainable on facts and in law. This issue has been framed at the instance of the defendant who is in his written statement simply stated that the suit is not maintainable in its present form, but the defendant has not stated the reason as to why and how the suit is not maintainable. On going through the case record, it is revealed that the plaintiff filed this suit claiming damage of ₹1 crore only for causing injury to her reputation. There is no evidence to show that the suit is not maintainable in the present form. Rather, from the case record, it reveals that this is a civil nature suit. Hence, I have nothing to hesitate to hold that the suit is maintainable in its present form. Thus, the issue number 2 is also decided in favor of the plaintiff and against the defendant. Then issue number 3, whether the suit is bad for non-joinder of necessary parties. The defendant has contended in his written statement that the suit is bad for non-joinder and misjoinder of necessary parties. It is stated that Dr. Debashish Kaur, ex-principal of Kachar College, Silchar, State of Assam, the Director of Higher Education, Govt of Assam, each and every member of the governing body of Kachar College as well as Kachar College itself ought to have been made parties in the instant suit, and the suit cannot be decided in absence of them. The plaintiff filed the suit damage from the defendant for circulation of false and fabricated statement against the plaintiff by 2 numbers of pamphlets allegedly by the defendant, and the plaintiff has not sought any relief from any other person. I find that the defendant failed to prove that, and the suit is bad for non-joinder of parties. Accordingly, this issue is decided in negative and against the defendant. Then issue number 4, whether the suit is filed within the period of limitation. The answering defendant pleaded that the suit is time-barred. The plaintiff filed the suit for compensation for defamation for libel and slander, and the period of limitation for filing such suit is 1 year. In the pleading, the plaintiff stated that the defendant, by addressing a pamphlet without any date, probably sometimes in the month of May 2016, to the respected members of Kachar College family, circulated the same to the general public and also endorsed copies to Education Commissioner, Govt of Assam, DHE, Assam, and the Director of Higher Education called the plaintiff and the defendant to attend his office chamber on 25th May 2016. The plaintiff further contended that when the defendant failed in his attempt to yield result with such false communique, he again made another pamphlet similarly undated, probably in the month of January 2017, addressed the Honorable MP Silchar constituency, sent and circulated endorsing copies to all sundry, including Commissioner Higher Education, Assam, and also circulated the same to general public with caption, subject Kachar College Scam and Scandal 2015-16. The plaintiff was directed to submit a detailed report on the matter by the Director of Higher Education, Assam, by letter dated 19 January 2017. The Director of Higher Education also visited Kachar College on 20th March 2017, and by letter dated 23/3/2017 directed the plaintiff to show cause, and the notice was received by the plaintiff on 24/3/2017. The suit is filed on 3/4/2017. I find that the suit is not time-barred. Hence, this issue is also decided accordingly. Issue number 5, whether the defendant, by way of 2 numbers of pamphlets, document 1 and 2, defamed and lowered the plaintiff to the estimation of the higher education authorities and other right-thinking persons in the vicinity. The plaintiff sought damage on the ground that the defendant defamed her. Generally, defamation is an action of making untrue statement about another which damages his or her reputation in the society. In the instant case, the plaintiff filed this suit for circulation of some statement against her in some pamphlet. So in this case, the plaintiff must prove that an untrue statement is published and the statement is defamatory and cause harm to her reputation and profession and was made without any reasonable justification. If the plaintiff is able to prove the above criteria, then the burden of proof is shifted to the defendant that the statement is true and with reasonable justification. In a defamation case, there are 2 defenses of the defendant. Firstly, justification by truth, and secondly, fair and bona fide comment. Let us see as to whether the plaintiff is able to prove her case. The plaintiff as PW1 in her evidence on affidavit reiterated the story of the plaintiff. The plaintiff stated that defendant, by addressing 2 numbers of pamphlets without any date, circulated the same to the general public and endorsed copies to Education Commissioner, Govt of Assam and DHE Assam. The plaintiff stated that the defendant had written such highly derogatory, defamatory and false statement that it had lowered her to the estimation of the higher education authorities and other right-thinking persons in the vicinity. From the evidence of the plaintiff, it is revealed that she filed the suit on the basis of 2 numbers of pamphlets and certain letters issued by the director. However, the pamphlet failed to exhibit the same in the plaintiff failed to exhibit the same in the instant case. Under the law of evidence, it is necessary that the contents of documents are required to be proved either by primary or by secondary evidence. The documents having not been produced and marked as required in the Evidence Act cannot be relied upon by the court. In this regard, the reliance is placed on a decision of the Honorable Supreme Court in LIC of India and another versus Rampal Singh so and so, which says that at the most, admission of documents may amount to admission of contents, but not its truth. Documents having not been produced and marked as required under the Evidence Act cannot be relied upon by the court. Of the documents cannot be proved by merely filing in a court. Learned counsel for the defendant submitted that plaintiff had not exhibited the plaintiff pamphlets and certain letters referred to be issued by the Director of Higher Education addressing the plaintiff, on the basis of which he claimed defamation, and that this is a fatal to the plaintiff's case. I agree to the submission so made by the learned counsel for the defendant, as after thorough perusal of the case record, I do not find any just cause on the part of the plaintiff for doing the same. The plaintiff, as PW1 in a cross-examination had admitted that the Director of Higher Education, by letter dated 27/3/2017, show-caused her regarding manipulation of records, false appointment, misappropriation of fund, theft of trees of Kachar College, and subsequently another show-cause notice was issued by the Director of Higher Education regarding illegal appointment of 34 teachers, including manipulation of records and unauthorized utilization of ₹10 lakhs, and that there was an inquiry against her regarding aforesaid allegation. The plaintiff also admitted that on 17/7/2017, again the Director of Higher Education show-caused her regarding misleading the higher authority. Further, the plaintiff admitted that she had been placed under suspension by the Director of Higher Education by letter dated 27/3/2017, and a departmental proceeding was initiated against her. But the said facts were not stated in the plaint, nor any document had been submitted in the court to show the findings of the departmental proceeding or the status of the departmental proceeding initiated against her. The plaintiff also admitted that the document number 1 and 2, as mentioned in the plaint, relating to the charges of misappropriation of public money and financial anomalies were charge-sheeted against in her departmental proceeding. The evidence on record shows that the statement allegations in the pamphlets cannot be termed as false and fabricated statement. Rather, it is fair and bona fide comment. In a civil suit, the burden of proof is on the plaintiff, and in the instant case, the plaintiff has failed to prove and establish her case. Further, except the plaintiff and the plaintiff side has not examined any independent witness nor support her case. To prove defamation, the plaintiff side is to prove that the statement is read by another and the person who read the statement neglected and dishonored her. There is no evidence to show that after circulation of the statements of the plaintiff was dishonored by people, family members, and the higher authorities, and the society isolated her, and that she has been estimated low in their eyes. The allegations brought by the plaintiff is not proved by substantial evidence, and the plaintiff has also failed to show proof that due to the circulation of the pamphlet, she had sustained substantial loss and injury. From the above discussion, I find that the plaintiff could not make out an essential ingredients of defamation so as to claim legal compensation from the defendant, and as failed to prove the case of defamation. Hence, I have nothing to hesitate to hold that the defendant had not defamed the plaintiff. Accordingly, this issue is decided in negative and against the plaintiff. Whether plaintiff is entitled to get any relief. From the findings of issue number 5, it is revealed that the plaintiff failed to prove that she had been defamed by the defendant. The suit is based on defamation. Hence, I find the plaintiff is not entitled to one proof only from the defendant as damage, and the plaintiff is also not entitled to any relief in this suit. So, my lord, we have challenged this, my lord, because only on the basis of this pamphlets, because of this circulation of pamphlets, she was suspended from service, my lord. But subsequently, a departmental proceeding was also initiated against her. And in the departmental proceeding, my lord, nothing was established against her, and she was again allowed to reinstated in her service, and she continued her service till her retirement. These are the documents, because she could not submit these documents because at that time, during that time, the proceedings were going on, my lord. So these are some documents I have, my lord, regarding her reinstatement, and that nothing was found against her from the my lord, education department. So because of this, my lord, the defamatory statements and all, because only on the basis of pamphlet, my lord, departmental proceeding was initiated against her, my lord. And as per, my lord, your lordship may kindly see my grounds, my
These
lord.
pamphlets were not exhibited.
My lord, not
Pamphlets.
exhibited, but my lord, since it is proved, my lord, as per, my lord, section 58 of the Indian Evidence Act, my lord,
Admission.
in Evidence Act, my lord, the
Admission.
facts admitted need not be proved. Here, my lord, your lordship may kindly see my ground first at page 20, page 28, my lord. It starts from page 27, my lord, number 2, my lord. From the trial court, the learned trial court has committed a seriously illegality, not appreciating the true meaning of the term defamation by not taking into consideration that any information or statement which ultimately yield to be not legally acceptable for any legal action against the person, such statement or information on account of the resultant falsity would invariably harm the reputation of a person. Rendering the said person by making such false information of statement is liable have committed a defamation, and the person who has defamed in such a way shall have an enforceable right to claim compensation by way of filing necessary suit. Non-appreciation of the said basic and legal concept of defamation rendered the imputed judgment liable to be set aside. Then next page, my lord. Here, my lord, the appellant was subject to the learned trial court having failed to appreciate that the allegation on the basis of which the appellant was subject to departmental proceeding was ultimately found to be absurd, baseless, and apparently false by the disciplinary authority, exonerating the appellant from the said allegation, and on such exoneration, the said allegation apparently appears to be non-existent. Besides being apparently false, in such a situation, the appellant is lawfully entitled to be compensated for the damage, loss of reputation, status, dignity, and social existence by filing necessary suit for compensation. Then ground number 4, my lord, the learned court has failed to appreciate the true concept of defamation by not taking into account that the words which are not accepted by any authority competent to take legal action against the person against whom such words are spoken by other party shall be deemed to be false, and the person who was defamed by such words in order to bring a legal action against the other party alleging defamation and seeking adequate compensation need not be required to prove the falsity of the said words, committed grave error in law, and so and so. Then the next ground number 4, my lord. The learned court below had committed error in not taking into consideration the basic fact that the allegation made in the pamphlet is the basis on which certain charge of misconduct was brought against by the disciplinary authority. And in order to prove the said charge of misconduct, conducted departmental inquiry, and once on the conclusion of the departmental inquiry, the appellant was exonerated from the said charge of misconduct by reinstating in service and all service benefits admissible under rules. Falsity of the charges per se stood proved. And in such case, there is no further necessity in law requiring the appellant to prove the falsity of the said allegation once again in the suit and once again in the suit, my lord. So, then in next page, para 30, I'm reading ground number 7. For that, the learned my lord, trial court below did not take into account the most legal aspect of the matter, that a proved fact need not be proved in any subsequent judicial proceeding in view of section 58 of the Indian Evidence Act. And non-appreciation of the said material and legal aspect of the matter vitiated the legality or otherwise of the impugned judgment and decree. Then the next one, 8, is the learned trial court below committed gross error in not appreciating the basic fact that the defendant respondent published, generated and circulate the pamphlet booklet with actual malice, and that too at a higher level. And once the defendant respondent failed to discharge his burden of proof by adducing evidence to the effect that such publication, generation or circulation of the pamphlet containing serious defamatory statements was not made intending to malign the image, dignity, and social and personal status and existence of the appellant, and that too not with any actual malice. The impugned findings in view of such misconception and consequent non-consideration of the actual facts resulted in serious perversity of law. Then, my lord, I'm reading ground number 10. The learned court below has committed illegality in not appreciating the basic essential elements of defamation to the effect that defamation is a civil liability, plays a crucial role in safeguarding an individual's reputation from false and defamatory statements. Once the reputation and social, personal status and position is defamed in the estimation of the public at large by making any such false and defamatory statements with an actual malicious intention to affect or harm the reputation, the defamation may be said to have been resulted in rendering the person committing such tortuous or the act, and the impugned findings are arrived at by the learned court below is not legally sustainable. Then the learned court below has failed to appreciate the admitted fact that the allegation made in the pamphlet is one and the same on the basis of which charge of misconduct was attributed against the appellant by initiating disciplinary proceeding by the departmental authority. In order to prove the said charge, and the departmental authority have accepted the said allegation to be untrue, exonerated the appellant from the charge and reinstated her in post of in-charge principal of Kachar College, Silchar, with all service benefits. Allegations made in the pamphlet apparently appears to be untrue, constituting a serious defamation, entitling the appellant to the relief sought for in the monetary suit. And non-consideration of that legal aspect is also consequently vitiated the legality and otherwise of the impugned judgment. And number 12, an act of publishing an untrue statement which negatively affects the reputation of the appellant at its face value, and that too when the said allegation on the basis of which disciplinary authority brought certain charges of appellant against the appellant intending to take some legal action against her were not accepted by the said disciplinary authority by holding the same as untrue and false. The appellant under such factual circumstances did not have any further burden to discharge so as to prove the falsity of the said action. Then, my lord, your lordship may kindly see ground number 14, my lord. That the learned trial court below, having failed to appreciate the legal meaning of the term defamation by not appreciating that an act which harms the reputation of an individual or entity involving the element of falsity and intention to cause injury to one's reputation, and consequently such act is liable to constitute a civil wrong, and any persons who have made such defamatory statement causing harm to reputation of others is liable to compensate the other person for the harm or injury suffered by the said person committed a serious error in law, and so on. So, my lord, here, my lord, the allegations made in the pamphlet, my lord, is the sole basis on the basis of which the trial, my lord, the petitioner, the disciplinary proceeding was initiated against the appellant. So now these things need not be proved, my lord, because she has already been exonerated from all the charges by the department. And she also, my lord, was reinstated in her service. She completed her service, and now at present she is the retired principal, in-charge principal. And regarding the exoneration, my lord, these documents I have, my lord, your lordship may kindly produce.
It is in the record?
No, my lord, not in the record, my lord. I have collected, my lord.
Cannot check. Only under order.
Yes, my lord.
41, rule 27 only I
Yes,
can
my
check.
lord.
Order 41.
Yes, my lord. Is there. Earlier it was not placed. They should have placed. Because at that time the read proceeding was going on in this court.
Okay.
That is why they could not place.
Then defense story will come in here after break.
Yes, Your Lordship.
And I place some judgments in my favor.
Then we will hear you. Now, you have not completed your hearing, no?
I have completed my hearing, but judgments, my supporting judgments are there. I'll place, my lord.
Not today or some other.
Today, my lord, at 2 p.m. I'll
Okay,
collect.
today at 2 p.m. Then you will go through the
Yes,
judgments.
ma'am.
Then other cases I won't be able to take up because at 3:15 I think we have a reference.
Yes, Your Lordship, with respect to item number 16, it's fixed for hearing, interim order may be continued in that case.
Item number 16.
Yes.
For the respondent.
Okay. Parties are represented. List this matter. This was for hearing.
Yes, yes, yes.
Well, list this matter hearing or data detail. Daily. Interim order shall remain in force till the next date of listing. Yes.
15. Obliged.
Yes.
Fixed today
Yeah.
for hearing.
It was this matter I think we will have to carry forward tomorrow, huh?
A date may be given. That's
Item 15. Land Council, Mr. Idhar is present for the appellant. You are for the appellant?
Appellant.
Who is for the
CGC.
CGC? Okay. Matter could not be taken up due to paucity of time. List this matter.
19th.
19 March? Okay, on 19 March.
Obliged.
এটা থাকো কেনেকে থাকো
Thing is that only on the ground that the pamphlets were not exhibited, the issue number 5 and 6 were decided against the plaintiff, my lord, the appellant, my lord. So this should not have been done because, my lord, only on the basis of the pamphlets, disciplinary proceeding was brought against her, and it was found as totally false. So she was honorably reinstated in her service as in charge principal, and he completed her service period and she retired. Now she is retired. So it is proved that all the allegations were false and defamatory. So this is my submission.
You wanted to submit some
So,
judgment?
yes, my, because of the shortage of time, my lord, I could not collect, my lord.
We'll get it tomorrow?
Yes.
Then we'll continue and conclude tomorrow then.
I have completed my submission. I'll only submit,
Yes, we will.
furnish the.
At
this.
2 we will start and then we will finish it in the afternoon.
Yes, my lord.
Then he can place his submission there.
Yes.
Now you can place your submission, then tomorrow we will continue with our judgments.
Okay, so I'll place my submission.
Yeah.
Oh.
Yes.
So, Your Honor, basically, this is a case of defamation which has been filed against us.
And which against you, they are demanding 1 crore.
1 crore. So, Your Honor,
So you have to be very careful now.
I am at the mercy of your lordship. 1 crore is a huge amount. It will be very.
I know.
So, Your Honor, what basically, if we go through the judgment,
Hmm.
what it suggests is that the defamation case has been filed, and as per the norms of the legal procedure, whenever there is any allegation against any person, suppose I say he X has committed murder or X has committed robbery, so a procedure has to be followed. Like for a civil case, a CPC has laid down a procedure, like how an evidence is to be adduced, how the plaint has to be written, and then how a trial has to be conducted. And then we arrive, the presiding officer, and then we come to a conclusion, okay, so X has committed the crime or X has committed defamation. So in this case, if your lordship will kindly look at the basic fundamentals of the basic procedure, how a case has to be conducted has not been done. So So, Your Honor, I would like to, though she has read it, but this paragraph is actually very important. That is the issue number 5.
Issue number 5.
To number 5, I will take 5 minutes of your lordship to go through. That is at page 152.
Oh, এখন কি কৰিবলৈ দিলে? গোটেই প্ৰিণ্ট আছে। কি কৰিবলৈ দিলে? গোটেই প্ৰিণ্ট আছে। বেলেগ আছে নেকি? বেক চাইড চোৱা আকৌ তুমি, গোটেই প্ৰিণ্ট আছে। বেক চাইডটো হেৰি আছে, বেলেগ বহি এখন দিলে হৈ যাব। আৰু এখন আছিলে অথনি, দেখিছিলো। বহি এখন দিলে হৈ যাব। বেয়া বনাইছে দেই, গোটেই প্ৰিণ্ট থকা দি। ৰাইটিং পেড বনাইছে, দিয়া। এভেইলেবল পেড এখন দিয়া। এখন কি কৰে কৰক আৰু তেওঁলোক। এনভেলপ চেনভেলপ বনাব পাৰিব আৰু। পেড এভেইলেবল ৰেডিমেড পেড আছে নে? দিয়া সেইটোকে দিয়া, তোমাৰ হাতত থকাটোকে। না হ'ব, প্ৰিণ্ট নহ'লেও হ'ব, একো নাই। এইটো তুমি চোৱা কি ৰেডিং পেড বনাইছে। Okay.
So if I may read, issue number 5, whether the defendant by way of 2 numbers of pamphlet, that is marked as doc 1 and document 2, defamed and lowered the plaintiff to the estimation of the higher education authorities and other right-thinking persons in the vicinity. So paragraph number 26, the plaintiff sought damage on the grounds that 152.
Yes.
Issue number.
So these are not exhibited, no?
This
Document 1.
document, no, not exhibited. Wait a second. The plaintiff sought damage on the ground that the defendant defamed her. Generally, defamation is an act of making untrue statement about another which damages his or her reputation in the society. In the instant case, the plaintiff led this suit for circulation of some statements against her in some pamphlets. So in this case, the plaintiff must prove, I just want to emphasize on this, must prove that an untrue statement is published, the statement is defamatory, and the caused harm to her reputation and profession was made without any reasonable justification. So this is the basic crux. So that in paragraph 27, if the plaintiff is able to prove the above criteria, then the burden of proof is shifted on the defendant that the statement is true with reasonable justification. In a defamation case, there are 2 defenses of defendant. Firstly, justification by truth, and secondly, fair and bona fide comment. Let us see as to whether the plaintiff is able to prove her case. The plaintiff is PW1 in her evidence on affidavit reiterated the story of the plaintiff. The plaintiff stated that the defendant, by addressing 2 numbers of pamphlets without any date, circulated the same to the general public and endorsed copies to Education Commissioner, Government of Assam and DHE Assam.
Why was the defendant bent upon
Defendant is the president.
defaming the plaintiff?
It's the, yeah, that's what your lordship. The defendant is a president of the same governing body of the college.
Defendant.
Defendant.
President was president, no, not
Yes.
now.
Not now. That point of time, he was also the president of the governing body. And your lordship, these are not some facts, like, no, which has been proved, like not defaming. These are like not untrue statements. These are true facts which have been stated in the pamphlet. But nevertheless, I will not go into those. I'll just first read this judgment, then I'll come to those facts, your lordship. The plaintiff stated that the defendant had written such highly derogatory, defamatory, and false statement that it had lowered her to the estimation of the higher education authorities and other right-thinking persons in the vicinity. Now, your lordship, this paragraph is very important for now. From the evidence of the plaintiff, it is revealed that she filed the suit on the basis of 2 numbers of pamphlets and certain letters issued by the Director of Higher Education. Now, however, the plaintiff failed to exhibit the same in the instant case. Under the law of evidence, it is necessary that the contents of documents are required to be proved either by primary or secondary evidence. The documents having not been produced and marked as required under the Evidence Act cannot be relied upon by the court. In this regard, reliance is placed on the decision of the Honorable Supreme Court of India, and so where it is held that at most admission of documents may amount to admission of contents but not its truth. Documents having not been produced and marked as required under Evidence Act cannot be relied upon by the court. Contents of the documents cannot be proved by merely filing in a court. 34. See, now your lordship may come to paragraph 31. The plaintiff SPW1 in her cross-examination had admitted that Director of Higher Education by a letter dated 20 show caused her regarding manipulation of false statement, appointment, misappropriation of fund, theft of trees of the Kachhar College, and subsequently another show cause notice was issued by the DHE on 11/4/2017 regarding illegal appointment of 34 teachers, including manipulation of records and unauthorized utilization of rupees 10 lakh, and that there was an inquiry against her regarding the aforesaid allegation. The plaintiff also admitted, so there is an admission here, that on 17/7/2017, again, the director DHE show caused her regarding misleading the authority. Further, the plaintiff admitted that she had been placed under suspension by the DHE by letter dated so and so departmental proceeding was initiated. But the said facts were not stated in the plain, nor any document had been submitted to the court to show the findings of the departmental proceedings or the status of the departmental proceeding initiated against her. The plaintiff also admitted, there is another admission, that in document number 1 and 2 as mentioned in the plain reading relating to the charge of misappropriation of public money and financial anomalies were charge sheeted against her in departmental proceeding. The evidence on record shows that the statements, allegations in the pamphlets cannot be termed as false and fabricated statements, rather it is a fair bona fide comment. Your Lordship, these are not some wild allegations I have put against someone. These are some statements which were, nevertheless, though they are not part of the judicial records, because till a document has been exhibited, they don't form part of the judicial records, because when a presiding officer or the honorable court has to take cognizance of any document, the document first has to be exhibited. And when a document has been exhibited, then only it forms part of the judicial records. And then the honorable court can form its opinion after contrasting it with the cross-examination of the witness and everyone, whether the document is, it can form its opinion basically, whether the document is correct or not, or whether the defamation has happened. But in this case, the basic tenets of the basic procedure laid down in the CPC has not been followed. So these documents doesn't have any evidentiary value or any legal standing today. Next, Your Lordship, paragraph number 32. In a civil suit, the burden of proof is on the plaintiff, and in the instant case, the plaintiff has failed to prove and establish her case. Further, except the plaintiff side has not examined any independent witness to support her case. Now, Your Lordship, on this aspect also, I'd like to make an submission. Basically, defamation happens when we say a person X has done something, and then how a defamation can be proved. Suppose I say a person X has done something, so it should be heard by a person C, another person, in whose eyes, after reading that point, my goodwill or my reputation has come down in the eyes of that third person, and that person has to be examined in the court. So in here, there is no witness had been brought, never. Only I am stating that I have been defamed. I go to the court and I don't exhibit any document. So there is nothing which shows that a defamation has taken place. There is no evidence, then if I may continue, there is no evidence to show that after circulation of the statements, the plaintiff was dishonored, this the exact same thing I'm saying, by the people, family members and the higher authorities, and the society isolated her, and that she has been estimated low in her eyes. The allegations brought by the plaintiff is not proved by substantial evidence, and the plaintiff has also failed to show proof that due to circulation of the pamphlets, she has sustained substantial loss and injury. From the above discussion, I find that the plaintiff could not make out the essential ingredients of defamation so as to claim legal compensation from the defendant, and has failed to prove the case of defamation. Hence, I have nothing to hesitate to hold that the defendant had not defamed the plaintiff. Your Lordship, and another aspect is that which Your Lordship had already taken into consideration when she was arguing the case, that some documents, it has been stated that she had been exonerated after the inquiry was conducted, Then the department found no allegations against her. But unfortunately for her, those documents were never part of the proceedings. And today, if actually they should have filed an application under Order 41, Rule 37 and seek permission of this court to file additional evidence rather than only filing this appeal. But now it's at the stage of hearing. So your lordship, today those statements, even though they might be correct, I don't know whether they are true or not true, but unfortunately or fortunately they are not placed, and there is no value or evidentiary value which shows that this kind of statements will hold any ground today. Your lordship, well, I'd like to place two judgments regarding the same concept. One is your lordship judgment of the Honorable Supreme Court in 2010 4 SSC 491. I will take your lordship with the first initial summary. Head notes. Departmental inquiry procedure, evidence and proof. Procedure for proving documents when civil suit is filed, questioning validity of departmental inquiry. So held appellant employer should have proved contents of documents either by serving notice on respondent employee under Order 12 Rule 2 CPC or by calling witness. Now, your lordship, this is important. Mere fact that documents were exhibited in civil suit does not mean that the contents stood proved. In the absence of such proof, appellant employer could not be considered to have proved its case that adequate opportunity was given to the respondent employee, and hence that inquiry had been conducted validly. Life Insurance Corporation of India, staff, so and so. Then, your lordship, second B, the head note, Evidence Act 1872. Second, proof of contents of a document held, mere filing or exhibiting of a document in court does not amount to proof of its contents. Admission of a document in court may amount to admission of its contents, but not their truth. Further held, document not having been produced and marked as
This has been cited by the trial court.
This has been cited by the trial court.
I believe so.
Yes, yes, your lordship, it has been cited. So this shows that, and this is actually, your lordship, the second step. The first step has already not been complied with. That is exhibiting the documents. Then this comes. So the stages has to be. So I will, and another judgment, your lordship, is of the Delhi High Court. I'll just read it. Paragraph 6, if I may take your lordship directly to. Internal page 87.
Para 6?
6. Let me now look at the law. Any document filed by either party passes through 3 stages before it is held proved or disproved. These are: first stage, when the documents are filed by either party in court, these documents, though on file, do not become part of the judicial record. Second stage, when the documents are tendered or produced in evidence by a party and the court admits documents in evidence. A document admitted in evidence becomes a part of judicial record of the case and constitutes evidence. Third stage, the documents which are held proved, not proved or disproved when the court is called upon to apply its judicial mind by reference to Section 3 of the Evidence Act. Usually, this stage arrives at the final hearing of the suit or the proceedings. Your lordship, my submission is this much only. Like, the documents were never exhibited, they were never formed part of the proceedings, judicial proceedings. And more than that, they have not stated how my statements are untrue, because at the basis of defamation is something which you have to prove that I have made a wrong statement, and which, because of which my stature or goodwill in the society has come down, and some third person who has read it has actually, after reading those statements, looked down upon me. But in this case, no statements are thus. Rather than she is admitting, I have been placed under suspension, I have been asked by the court to go through inquiry proceedings. So these statements, rather than she is admitting whatever the statements are made in the pamphlet, or on the basis of which she is trying to say the defamation has occurred, that those statements are rather true. So there is no such stand.
These statements she never admitted. She says on the basis of the pamphlets, inquiry proceeding was drawn up, and the minor charges were framed only on the basis of the pamphlet. Not nothing was found out by the Education Department. There was no charge, nothing against the appellant, my lord. Only in terms of the whatever allegations are there, these allegations are in the pamphlets.
And the
On the
pamphlets were
basis
never part of the
Yes,
record.
my lord, that
So
is the-
pamphlet,
yes.
nevertheless, it doesn't hold.
Yeah, my lord, but it is, all these allegations were reflected in the pamphlet, and only on the basis of the pamphlet, departmental proceeding were drawn up and charges were brought up. All these charges, these reflected in the pamphlets, my lord. That she admitted the, yes. this,
Basically, this has been
uh,
a gross violation of the rules and laws laid down by the CPC. They have not followed, unfortunately, they have not gone through the entire procedure, how we have to arrive at a conclusion. So at this stage, it is too late.
One question that your appeal, in the appeal memo, have you submitted that you have been reinstated?
Yes, my lord.
Well, don't think so.
Yes, I have. In my statement also, and also in the grounds also, repeatedly I have stated. In page 24, my lord.
So this, you have been reinstated. So this
Yes,
is
ma'am.
one ground why this case is, judgment is wrong.
Yes, my lord.
Even your lordship, even if it has been reinstated, she is bringing new facts now.
With all service
Because
benefits.
those facts.
No, no.
At para
She-
6 of
she
my
is
appeal.
Able to please. But reinstatement is not new. I think it is.
New because
in the
the-
earlier case.
No, only the up to the point of suspension. There is
up to the point
no
of-
discussion about what has happened in the inquiry, whether she was
That
reinstated.
proceeding was going on there and here, my lord. They should have placed it, my
No.
lord.
We should,
Para 6, page 24, my lord.
because it would be bringing new facts only indirectly.
Okay, then we will spill over to tomorrow or day after tomorrow. Not day after tomorrow.
Yeah.
You'll come on day after tomorrow. Are you willing to come?
Tomorrow, my lord.
Tomorrow. Tomorrow, I won't think it will be possible. Give it. Fix going. That too.
Then
What about
Saturday, my lord.
Huh?
Saturday.
Saturday. You'll come on
Sure,
Saturday?
actually, our part has been concluded. She has only to place the judgment.
Yes, yes.
So she can just place the judgment. We can come or whatever your lordship will.
Then I can pass an order also.
Yes. Because
If, so it was decided that on Saturdays, no order against the parties will be passed.
Yes.
So there will be some order against some party. So will I be able to pass an order? It was decided and it was assured also to the bar.
okay.
Because many people are not willing to come and work on Saturday.
Your lordship, if I may suggest one.
Streaming to off to that.